Hey everyone, this is Christie Asselin with the Law Office of Christie Asselin. Welcome to my YouTube channel. Estate Plan with Christie is what I have named it. This is where I break down estate planning, administration, wills, and trusts for you in a way that is simple and easy. I help my clients protect their assets and loved ones through drafting wills, trusts, and comprehensive estate plans. I also support families in honoring the wishes of their loved ones who have passed. I am located in Los Angeles, California. I have a home office in La Crescenta, as well as an office in Pasadena. You can find me at my website, lawyerscma.com, and via Instagram at Estate Plan with Christie, and of course here on YouTube. Okay, now who does this next post I'm about to talk about apply to? Let's say you have a loved one who was living in California and has passed away, and you now think you need to open up a probate to get your loved one's assets to yourself and or other heirs or beneficiaries. I'm going to go over a checklist for preparing for a probate petition and hearing. Okay, I will also include this in my blog at lawyerscma.com, so you can access the checklist and print it off if you'd like. Okay, first of all, checklist item number 1. You need to locate heirs and beneficiaries and contact them. Okay, when you file a probate petition, a petition for probate, the petitioner has to say that 10 times fast. Okay, petitioner has to notify all of the heirs and beneficiaries of the probate petition. The standard is to make a quote unquote reasonable effort to do so. And the contact information will include names, addresses, and relations of the heirs and at law and the will beneficiaries. So it's going to include the living relatives of the deceased person, and also anyone mentioned in the wills and in the will if there is one. That would also include any charitable organizations, as well as any contingent beneficiaries. Here's the deal: heirs and beneficiaries have the right to challenge a will, so they have to receive notice. If they don't receive notice and you go through a full probate administration, there's going to be problems perhaps later. So it's just better to follow the law strictly and to alert all the folks who are entitled to notice. 2, characterize the assets. This is a really, really important thing to do at the outset. What do I mean by characterize the assets? I mean, divide the assets to those assets that are subject to probate and those assets that are not subject to probate. And those are the assets that pass as a matter of law. The reason this is so important is, well, I'll get to this in a minute, but essentially if you have under $166,250 in probate assets, there's easier ways to get through the process of administering an estate. So it's really important that you be able to distinguish between assets that are subject to probate, assets that are not subject to probate, okay? Even when I talk to my clients about this, it's something that's really easily forgotten. And I have to remind them a lot about it. And this concept is just tough to digest, I suppose. So I'm going to go into detail about what assets are subject to probate and what assets are not subject to probate. Assets that are not subject to probate, it's a much smaller class of assets. Assets subject to probate is basically everything but things that are not subject to probate. So assets not subject to probate include community property assets that pass to a surviving spouse or registered domestic partner, assets held in joint tenancy, assets with beneficiary designations such as retirement accounts, life insurance policies, annuities, and payable on death bank accounts. Also, trust assets, which is why it's so important to do some savvy estate planning and create a revocable trust while you're living. And lastly, life estates, which are pretty uncommon, but I'm mentioning it because I think it's important to remember. Assets that are subject to probate include, well, now that list isn't exactly totally exhaustive, but it's close. And the assets that are not subject to probate is everything but the things I just talked about, which are community property, joint tenancy assets, assets with beneficiary designations, such as retirement accounts, life insurance policies, annuities, and payable on death, bank accounts, trust assets, and life estates, okay? The next thing to consider is, are there any summary proceedings available? The reason we're doing this is because, the reason I'm going through this particular issue is because probate petitions and petitions to administer an estate take a long time. They can take anywhere between 9 months and 2 years. It's also very expensive and time consuming. So when I sit down with my clients who are looking to probate their loved one's estate, I'm going to first look for ways that I can avoid having to file a full probate petition, because I want my clients to spend the least amount of money possible and to get the same remedy, which is essentially getting the proceeds, getting the assets out to the right people. Let's do it as cheaply as we can and as quickly as we can. Okay, summary proceedings. Summary proceedings are a more straightforward and less time-consuming process than an entire probate proceeding. These are excellent remedies when the value of the estate is small. There won't be any tax consequences, and the number of successors and interest to the assets is minimal. The decedent has few or no debts or liabilities, and there are no disputes about entitlement to the property. Believe it or not, it's hard to get all of those factors together, but assuming you can, and you hit all those check marks. Let's talk about the 5 types of summary proceedings. First is collection of personal property in small estates by affidavit or declaration. The second is succession to real property within California by one of the following methods, depending on the gross value of the California real property in the state. It's possible to do a summary proceeding if the real property gross fair market value is under $55,425, or if the real property gross fair market value is over $55,425 and the total estate value does not exceed $166,250. Truthfully, it's pretty hard for those standards to be reached, but it is available if possible. I'm always going to look at it. The third one is transfer to a surviving spouse, registered domestic partner, minor child, or another dependent. You can essentially, it's called set aside the small estate. You can pass property to the surviving spouse or registered domestic partner under the rules of community property. And you can determine and confirm by court order the property passing to a surviving spouse or registered domestic partner. Obviously, these are a lot of options. It's important to meet with counsel to talk about which is going to be the best option for you. The fourth item on my checklist here is, can you file a Hegstead petition? I love a Hegstead petition. I find it very satisfying. It's again a remedy or a procedure used to avoid a full probate administration. This is when someone has a revocable trust, they created one while they were alive, and you can prove that although they did not properly title the estate, the asset in their name as trustee, they meant to. And that for that reason, the court should consider that property, that piece of property to be a trust asset, thereby avoiding a full probate petition. So that's really good news for folks if we can do that. And I've done that successfully a few times. Okay, publish and file the will. There is unfortunately, or fortunately, no dramatic reading of the will. I think we see this in TV a lot, in movies, but I can't even begin to imagine how dramatic that could be, and potentially really tragic and sad. So we don't do that. I don't think any state actually does that. I'm not sure who came up with that concept, but it's not legal. So this doesn't happen in reality, but what does happen is that the beneficiaries and heirs can access that will because the executor is required to file and publish, will file the will with the probate court, who then publishes that will. And that's a requirement whether or not a probate proceeding has even been opened. Okay, those are my 5 items on the checklist. I will be sure to publish this on my website at lawyercma.com. Feel free to reach out to me with any questions, and hope everyone is doing great.